Hello and welcome everyone. We'll get started in just a moment. Just want to give people a chance to get their audio preferences settled before we begin. It seems like a pretty good critical mass, so I'll make sure that I type this out for people that are joining a bit later, but welcome to today's webinar. Before we begin, I just want to cover a few technical details. If you haven't joined us for a Zoom webinar before, it's very similar to Zoom meeting, but with a couple key differences, which you've probably already noticed. The biggest one is that your video and mics are disabled by default, so you don't have to worry about being seen or interrupting us, but it does limit your interaction to text-based channels. So the first is a familiar one with chat. The only difference is that it defaults to hosts and panelists. So if you want to have discussion with everyone, just make sure that you direct it to everyone in the to window there. And then if you have any questions, you can ask those at any time using the Q&A thing. The Q&A button, when you press that, you can choose to ask questions anonymously if you so choose, but other people will be able to view the question and comment to it or thumb it up if they so choose. So without further ado, we'll just get into our panel discussion today. Obviously, this is the 50th anniversary of Title IX, and we're here to kind of give a brief history of the statute and an update on the newly proposed Title IX regulations. And we have individuals from a number of different ACRO groups and also a representative from NASPA here today. So to kick things off, I'd like to give it to Melissa Manuel, for the chair of the Women's Caucus.
Thanks, Mike. My name is Melissa, and I am the co-chair of professional development for the Women's Caucus. We were founded in 2018, and we support professional development, networking, community building, and the discussion of issues specific to all women, including cisgender and transgender women. We are open to any ACRO members who are interested in promoting scholarship, empowering, and developing all women and anyone who identifies outside of cisgender constructs in higher education. We really are excited to be working today with our fellow caucus community groups and NASPA, and excited to have everybody on board. I'll pass it on to Tammy.
Thank you. First of all, my name is Tammy Johnson. I'm co-chair of ACRO's LGBTQIA+ caucus. I want to thank our presenters for being here today, as well as our attendees. Our caucus works to advocate and educate on behalf of LGBTQIA+ members in higher education, and we welcome any member of ACRO who would like to join our caucus, regardless of identity or orientation, if you would like to work on behalf of that population. Thank you again for being with us, and I'm going to turn it over to Michelle.
Great, thanks, Tammy. My name is Michelle Mott. I am the Director of Public Policy here at ACRO. And thank you for being here today. So as Mike mentioned, this summer did mark the 50th anniversary of the passage of Title IX. Since then, the interpretations of discrimination on the basis of sex have evolved and expanded over the years to include equal opportunity in athletics, sexual harassment and assault, and pregnancy. And then most recently, the Biden administration proposed new Title IX rules to expand protections based on sexual orientation and gender identity. These rules would also overhaul how schools respond to sexual misconduct complaints and are quite expansive. So we are very grateful to have Dr. Jill Dunlap here with us today to discuss these new rules and their potential impacts for campuses and students. Dr. Dunlap is the Senior Director of Research, Policy, and Civic Engagement at NASPA and has done extensive work in this area over the course of her career. So thank you for being here, and I'll turn it over to Dr. Dunlap.
Great. Thank you all so much. I'm really just so excited to be here with you all today. I have a few quick slides because, you know, that's how we do. But I wanted to leave time for questions at the end as well, and let you all engage with, you know, what I have to say. So I'm interested to hear from what you all are thinking of, and you know, how you all are engaging with some of the newer Title IX regulations. So hopefully you all can see my slides. Happy birthday, Title IX. For those of you who have been around for a little while, like I have, you've seen a lot of the Title IX iterations and the ebbs and flows and what Title IX means to folks. I think, as NASPA, we have a lot of people who are really impacted every day by the Title IX rules and how they are differently interpreted, given on who, given who's in power at any given time in the Department of Education. And so, we are regularly engaged with discussions with the Department of Education and thinking through how this impacts our members. But I just wanted to sort of give you a couple of thoughts around what we were in particular honing in on when we submitted comments to the Department of Education on the new regulations that were proposed. And then also to talk a little bit, just really briefly, about the impact of the Dobbs decision and how that intersects with some of the things that are included in the new Title IX proposed regulations, as well as some ramifications for student athletes, particularly transgender athletes and their ability to participate in sports. And then, like I said, I'll just open it up for questions. So, NASPA is really committed to, just sort of in terms of background, I report up through the NASPA Research and Policy Institute. I'm the Senior Director for Research Policy and Civic Engagement there. So I'm like the Michelle of NASPA in some ways. And so we really are quite committed to, we have a very small team of policy folks at NASPA. It's myself and two other colleagues who work on these types of issues, but we really do, work really closely to do policy analysis that assesses the impact of different federal and state level policies on our members, and then develop tools and resources for practitioners. And then we, provide webinars and live forums and partner with our other association partners in the field on a lot of these issues to understand the full impact that it has on folks who are working in student support roles. So in terms of the Title IX regulations, we again are a small team. So we thought, it's not really fair for us to just sort of decide for all of our members what we should speak to in terms of the proposed regulations. So we convened a sexual assault advisory council in the months leading up to the proposed rule being published. So we were like, look, we know it's going to change because there's been an administration change. So we pulled together a range of folks that were representative of our membership, but also really heavily involved in these issues on campus. So we had folks from law enforcement, conduct, advocates, respondent support for folks, Title IX coordinators, investigators, decision makers, which were all roles outlined in the current regulations that we're operating under. And so we got their perspectives in looking at the new regulations, and then drafted our comments to the Department of Education based on that feedback. And so we sort of bucketed them in terms of things that were like, hey, way to go. And then some things that we were like, we have some concerns, and this might, require some adjustments. And so in terms of the things that we were really appreciative of that the department included in the proposed regulations, included the expansion of the definition of disciplinary jurisdiction. One of the things that we were really concerned about under the current regulations that we're, operating under, that were put forward by the Trump administration, was the idea that you could only really investigate a subset of harms that were occurring to students on your campus. And so from a student perspective, that's really hard to understand, right? If I'm assaulted and I don't know if the campus owns the house that I was assaulted in, does it count under Title IX? And so that was a really confusing piece for students, and often for the student support people who were advising students, right, if they came forward and disclosed harm. And so it also excluded study abroad programs. So that has been expanded, and now off-campus locations and study abroad programs are included in any type of harm that a student wants to bring forward to their campus in terms of a formal disclosure or making a formal report. We also really appreciated the return of the definition of sex-based harassment that is being proposed, and that is including severe, pervasive, or objectively offensive. Under the current guidelines, it says severe, pervasive, and objectively offensive. And so you really there could be an argument made that if you were sexually assaulted once, right, it was severe, but is it pervasive and objectively offensive, right? And so I think there was a lot of exclusion of different reports that came forward based on that really narrow definition. We really appreciated the requirement to provide support for both parties, regardless of whether a report is filed. And then also training requirements for anyone conducting informal resolution processes. So we appreciated that the department kept the option open for students to pursue a less adversarial informal resolution process, but the current guidelines don't require any training. So it's kind of you can kind of throw anybody in there, right? And be like, yeah, we're going to do an informal process. And that can actually cause a lot of harm to both parties. So we were really grateful for the training requirement on that. And then in terms of, we had a lot of concerns. Our areas of concern included the expanded definition of responsible employees. And I think that would particularly impact your members because as you sort of watch the pendulum swing right around Title IX, the current regulations did not require all employees to be responsible employees. The current proposed regulations that will go into effect after the department, adjudicates all of the comments that came in, really, I think, can be quite harmful. And so, our suggestion to the department was, okay, if you increase the number of people who are required to tell the Title IX coordinator when a disclosure comes in or when a report comes in, then you should also increase the number of outlets that students have to confidentially disclose and sort of talk through what their options are as far as a formal report goes. And again, I think in some of the ways that I've seen this happen on college campuses that would impact your members is, do you get a disclosure from a student who had to drop out as a result of a harm and now wants to re-enroll, and they're disclosing why they dropped out to waive a re-enrollment fee or something. And then that disclosure as part of a separate process initiates a Title IX investigation, right? When really all the student is saying is like, here's the reason why I've dropped out and now I need to re-enroll and I'd like to have my re-enrollment fee waived. And so, in some campuses, if you have everyone being a mandated reporter, or if you have a faculty member who reads a paper where a student discloses that they've been sexually assaulted long ago, right? And now they feel the need to report that to the Title IX coordinator, that can feel really invasive to a student who has no intention of filing a formal complaint. We really also suggested to the department that supportive measures be centered in a non-Title IX office. And that is because any confidential support seeking that students may want to pursue really ought to be separate from a formal reporting office. I think it builds trust in the process among students. And then there's also, and I'll get to this in a minute, but there's some real significant concerns around students coming forward to ask for accommodations around pregnancy or parenting issues, which are now included in the Title IX. They were really highlighted and emphasized in the current proposed regulations, but where that information gets documented and how it could be subpoenaed or used against a student who, is in a state where reproductive health access is limited, that raises some pretty significant concerns. As far as informal resolutions, again, we had more thoughts here. We wanted the department to ban mediation and arbitration as one of those options, only because, when you have mediation, it's like both parties admit some sort of fault in a matter, and then you sort of tease out what you're going to do as a result of that. And so we wanted to be pretty clear in terms of the fact that a student who's harmed who wants to pursue informal resolution shouldn't be required to engage in the idea that they've committed some sort of harm in order to begin that process. And then we'd also like the department to require that informal resolutions be initiated by the reporting party so that they aren't being sort of maneuvered or encouraged or urged into an informal process because it's easier for the institution, or as a get out of jail free card for a responding party. And then we also asked the department just to require that both parties be allowed a support person and an advocate, or an advisor rather, right? So you think about lawyer and then also someone who's taking care of that student's emotional needs throughout the process. So those were our major areas of concern. We also just really partnered with a lot of other associations in thinking through and looking at their comments to the department. In particular, we signed on to and really appreciated the comments submitted by ACE and also the National Women's Law Center. They just had some really nuanced understandings of how the proposed regulations impact students who have experienced harm. And so we signed on as a supporter of their comments to the Department of Education. And then further, we, on the research team, we partnered with a Title IX investigator on a college campus, and we are, so we have both the association perspective and a campus perspective, and we're issuing a Title IX policy brief, which I'm happy to share with you all if you have any interest in it. And it's sort of saying like, okay, so here are the regulations, but here's where campuses could really take the regulations and then implement best practices. So we did a deep dive and did some literature review around like, what does the data tell us? What studies tell us about the way that campuses are doing these processes, right? So that we can make some data informed decisions about the ways that we handle these cases, in addition to, what the federal government tells us that we have to do. And then we continue to do professional development around Title IX. We have a Title IX certificate program, and we also have a Title IX informal resolution certificate program that are currently running, and we're going to run them again in the spring. And those are based on the current regulations because that's the system that we're operating under. But with an eye toward, okay, here's what the regulations say now, here's what you should be thinking toward on your campus as far as the proposed regulations go. And then we also are in the midst of doing some pretty significant research on the impact of Dobbs and how that has been, or what the intersections are there with the new Title IX proposed regulations. So as I said, I think prior to Dobbs, a lot of folks were like, oh, this is so great. The department is really recentering the importance of providing accommodations for pregnant and parenting students in a way that hasn't, pregnant and parenting students have always been covered by Title IX, but I think the department did a really great job in its current iteration of the proposed regulations to highlight and emphasize that, like, also, if you kind of let this go in your efforts to meet the needs of students who have experienced sex-based harassment, then you need to make sure that you're also including and meeting the needs of these students. The problem is that, and I could go down a real rabbit hole on this, but I promise I won't, but the proposed regulations require just a significant amount of documentation. Like, what are you doing to make sure that you're meeting the needs of students who experience sexual harm? What are you doing to, ensure or provide documentation that you're meeting the needs of students who come forward, who need accommodations because they are a pregnant or parenting student? Which is all great. And we think that campuses should be, in terms of holding themselves accountable and being accountable to the federal government, in terms of being in compliance with Title IX, that they should be making record of those accommodations. The problem that we run into, right, is that if students come forward and say, I need to dip out and, unenroll for the rest of the semester because I'm facing an unintended pregnancy, and then if that student reappears, a month later and says, no, I'd like to re-enroll, that those things all now are required to be documented by the current proposed regulations. And I think, again, I think that the Department of Education intent was to make sure that campuses weren't sort of disregarding pregnant and parenting student needs. But what happens now is that if you have record of that and you are in a state where reproductive access has been limited, there is, I think, pretty significant concern among the National Women's Law Center, among our folks that are providing these accommodations, Title IX coordinators generally, that these records now could be used against a student if they are reported by a roommate for, having sought an abortion in a state where it's banned, or, parents who come forward and think that their student has gone to a different state to get an abortion. There are just a lot of different ways that the intersection of that requirement to provide documentation of accommodation and, the needs of students in states where there are now bans in place, that could really prevent a threat to the privacy of those students and their student records. So, and that's just like sort of one piece of it, right, is the Title IX piece. We did a lot of informational interviews, and we're just in the beginning stages of this research project. So again, if you're interested in knowing more about it, I'm happy to share that. But what we did was held a series of information interviews with other associations, including the American College Health Association, which has a whole task force looking at this issue and like, what are, health centers on campus doing, as well as the Student Conduct Association and what happens in states where students are reporting on one another if they are in a state where there is a ban in place. And then also the National Women's Law Center. They just have some really great tools for students about knowing their rights and sort of protecting their privacy as they navigate these issues. And I think this is also fresh and new, that it's what we were finding when we met with other associations is that there isn't really strong guidance coming out to professionals in student support roles about what to do if you're in a banned state and what does what constitutes aiding and abetting in those states. And so there's some real serious concerns, I think, around how do we as associations advise our members on campuses in states where bans are in place. And honestly, the landscape is like trying to keep ahead of it is like, trying to claw your way out of quicksand, because there are so many different, the elections last week, right? Like there were a number of provisions at the state level that were struck down, but there's a sort of constantly moving target to try to keep on track of as far as helping student support professionals really understand the environment in which they're working and how that impacts how they support students. So the sort of three main buckets that we're hearing as concerns, again, very much tied to the new Title IX regulations are what training is being provided to student affairs staff, faculty, and student employees, right? So if you are an RA, are you training your RAs if you're in a state where there are bans not to provide that information to students who come forward if they disclose to you that they are wanting to seek, reproductive access in a specific way. Also, what data is being collected. And again, I think that is something that maybe would impact your membership specifically in a very different way in terms of like what information is coming in and being recorded for different processes that exist on your campus. And how are we ensuring the privacy of student records if those include things that could then be subpoenaable and prosecutable. And then also understanding aiding and abetting. And we talked to a bunch of different lawyers, like I said, at the National Women's Law Center and some other folks in the field. And they said that there's just a real misunderstanding of what might constitute aiding and abetting. And like, if you're a faculty member in one state where it's legal, right, and you're advising a student who's in a state where it's illegal, the online environment and understanding, again, the complex, like sort of puzzle that is, the intermixing of state legislation and what that looks like in a given day. How do people keep track of that and then advise students in a way that is not running afoul of state law, essentially. So our next step is we have affinity groups similar to what you all have here. And so we will be conducting focus groups with identity-based knowledge communities within NASPA, as well as role-specific knowledge communities. Because again, I think this impacts both traditionally minoritized populations on campus. And so the identity-based framework will provide us a really unique perspective. And then also looking at like, how does this impact fraternity and sorority life advisors, for example, differently than it might other roles on campus. And then finally, we're just sort of sitting around waiting, right, for the separate rulemaking process that will happen around transgender student athlete eligibility. So the current proposed regulations, we were really glad. There was a lot of praise for the fact that it explicitly bars discrimination and harassment against students based on gender identity and sexual orientation. So broadly, right, like you can't have policies and procedures that would disproportionately or discriminate against transgender students at your institution. However, they sort of kicked the can out a little ways and said, we're going to have an entirely separate rulemaking process on athletics with a focus on transgender athletes. And I think it was done with the best intent, and that is to say, they didn't want that in particular to be a challenge to the entirety of the Title IX proposed regulations because it'll be taken to court, right? And I think if they had included it, it would have immediately run afoul of several states that have passed bans on the eligibility of transgender athletes to participate in the sport with that aligns with their gender identity. And so they've sort of carved out this this thing, and they're like, yeah, we understand this is a special issue. We're going to put it over here and we're going to do a separate rulemaking on it. And again, I think it's done with the right intent to make sure that it will face fewer challenges in court once it's issued. But the separate process has been criticized by both those in favor and against transgender rights. So they're like, no, look, it should have been incorporated in the main Title IX rule. And folks that don't believe in transgender athlete rights are basically saying like, oh, well, we shouldn't, why do we need this at all? Like they shouldn't, that part shouldn't be included in this. And I do think, there are new NCAA rules that were issued in, or guidelines rather, that were issued in January. It's like very detailed around like testosterone levels and all of that. But I think, the timing of this will be really interesting to see if they can get an entire new rule proposed and go through the comment period and make them final while the administration, in the next 2 years. It took them 2 years to get us to this point on the current proposed regulations. So there's fears that they may not get to it. And then there's also questions around like, are they working on it? Or like, are they waiting until they finish up the Title IX rules and then they're going to go into, the negotiated rulemaking around transgender athlete eligibility. And so I think there's a lot of really great deep questions that could be, processed by folks in your membership around, the intersections around like where are students marking their gender identity upon enrollment? How does that, relate to, for example, their FAFSA application? And then how does that relate to NCAA eligibility and their new rules that came out in January? So like, I don't have really great answers on those because we're just in the waiting period for that. But I do think, if your membership wants to make comments on something once they're issued, that you all would have a really unique perspective around, transgender identity and how that is captured by an institution, and then how that then would impact students who are looking at athletic eligibility. So that was a lot. It was kind of three buckets, like the Dobbs, the transgender athletic rights, and then also looking at the proposed rules. But I'm also happy to answer any questions that you all may have for me, or if there's, anything that I can send you after, feel free to shoot me an email, and I'm happy to share our new Title IX brief, or, whatever might be helpful to you all. But are there questions that I can answer?
No questions yet, although I did remind people they can ask them at any point.
It's a lot to digest.
Yeah, thank you so much. This is really great information. I think sort of while we wait and see if folks are going to chime in specifically here, I know one question that we've gotten a lot is, when do the new Biden administration Title IX rules go into effect? And so just do want to clarify here that right now we're still in the proposed stage. The department had an open call for comments. They're in the process of reviewing those. They received many. So it's taking a while. So right now we're not exactly sure when those final rules are going to drop. In comments to the department, we did specifically ask like when that time comes to give ample time for implementation for institutions, because obviously this is going to be a large haul. But again, we're not exactly sure. And perhaps you have a few more thoughts as well.
I think we're sort of in the same boat, that we know that they have a lot of comments to go through. And I think, we've heard rumors that it could be as early as summer, but as late as fall, or maybe even 2024. So I think they'll do a really good job in terms of fidelity of addressing the comments that were submitted to them. But I think I worry about, as we head into the final 2 years of a current presidential administration, it just feels like a lot of back and forth, I think, for folks, and I'm sure for your folks as well. But it's like, just as we get one down, right, then they go through a process, and now we're looking at that one. And so I think it's very frustrating to think that we could get a new rule, even if it's as early as this summer, and then get a year and a half before there's a potential change in administration, and then we're doing this whole thing again. So.
Right, absolutely. Well, and honestly, historically, ACRO hasn't necessarily chimed in on some of the earlier iterations of these Title IX regs, because while it is adjacent to a lot of the work that we do, it didn't always, overlap. But the current rules that are in effect, as well as the new proposed rules from the Biden administration, dip far more into a lot of areas that do cover like student data and records and privacy issues in a way that kind of didn't necessarily exist before. And so it's been very interesting just for our association as well, as we wrap our heads around what all of this means and what all the impacts are, where they aren't overt. And sometimes you don't even realize until things are already implemented and in place, which is not necessarily the way you want to do these things, but as is the nature whenever you flip back and forth, essentially every 4 years.
Yeah, absolutely.
Yeah, and this question didn't come in through the public channel, but is there a good like a page or kind of a resource site that kind of summarizes everything you just put together, or for that matter, I guess, is this slide deck available somewhere, or can it be made available?
Yeah, I can absolutely send it to you. And our comments were listed on, I don't think it was terribly long. I think it might have been 9 pages or something, but I could share the link to our specific comments. But yeah, I'm happy to make the slide deck available as well.
Awesome.
And then I saw in the Q&A, something about, advice on folks in registrar and admissions offices collaborating with colleagues. And I just couldn't, like the fact that you're forward thinking about that, I think is a really good first step. But I think what we're hearing from a lot of people is that they are convening task forces. And I would encourage you to just sort of reach out and find out, from your Title IX coordinator, if your office is represented on that task force, because as Michelle just said, right, like these proposed rules impact you all in a different way and in more depth than maybe they have in the past. And I don't necessarily think that like vice presidents of student affairs or Title IX coordinators always think like, who should be at the table, right? And so I think it's a really great way, a really great opportunity and time, especially as we're waiting for the final rule to come out, to invite yourself to the table.
Great. And we have another one here. Let me get a. So Misty asked here, are there any accommodations in Title IX that are related to confidentiality and ramifications if someone says something on social media?
Are you, I guess my question, accommodations in Title IX that are related to confidentiality and ramifications. I think, well, social media is a whole thing, right? And I think it's also a little bit specific to if you're talking about sex-based harassment or if you're talking about the Dobbs impact. Because I think, well, and there's a lot of information in the current rules around retaliation. And I think if you're talking about sex-based harassment and someone talks about their experience of harm, that you could have someone come forward as in a responding party way and say that they were being retaliated against and file a counter Title IX claim. So social media can be so dodgy in terms of how it's adjudicated. If someone discloses, I think there was some provision in the current rule, and I'd have to go back and find it because I read all 700 pages because I'm a real party on a Saturday night. But I think there was something in there about excluding social media posts and disclosures at public events like Take Back the Night. But what some of the other comments I read were concerned about were actually thinking through, like, if a student discloses in a paper, or like I said, as part of a process at an institution for re-enrolling or something that has nothing to do with wanting to make an official report. When you've made everybody a mandatory reporter, what you'll find is that people sort of like want to be in compliance. And so, and if you're in Texas, right, like you could be fired if you don't report to the Title IX coordinator, if you're aware of a student who wants to come forward. And so I think, social media is an interesting one. And I can't remember if there's a specific carve out, but I could find out. I think I remember reading something specific to social media in the proposed rule around like not considering that an official report if it wasn't made to an official of the institution. But I'm not sure that at all answered your question. I'm sorry. There's so many ways that you can go with social media.
Yeah, and she did clarify that she's talking about like retaliation there too, fear retaliation. So I think you got to it. And I'm not seeing anything else at this time. I know somebody wrote earlier that it's just a lot of information to process, for sure. But really great presentation, very thorough.
Thank you. Well, yeah, I can make the slides available and, always available to answer questions. And we're so appreciative to be able to partner with ACRO and in these types of efforts. So I appreciate it.
No, we really appreciate it too. And I'm looking forward to see the brief that you mentioned that you guys will be coming out with in the near future. And we'll be sure to highlight that and make sure folks get that information here as well. Because again, like, we aren't doing as much research and work around it because this hasn't necessarily intersected as much as in previous years. But, we're sort of getting into that space and sort of figuring out what all the issues are, hopefully not going to be, but having a better handle on things ahead of time and having these discussions in advance. So we really appreciate your time. Thank you so much for being here today.
Thank you all.
Okay. Well, again, so Dr. Dunlap's time was limited here with us today, but I think it's been a really great discussion. As we're not seeing many other questions coming in, I suppose we can give a few more seconds just in case, but thank you all for joining us. Thank you to the caucuses for organizing this and, you know, for thinking about having this discussion. Mike is adding the links in the chat now. But again, as this continues to unfold, we're obviously looking to see when the final rules are dropped. We'll get that information to members as soon as possible, and we'll work to continue to advocate that implementation is sufficiently enough time for institutions to get these processes in order and to sort of figure out what the implications mean for our members. And similarly on the forthcoming regulations on athletics. So this will be a continued topic in this space.
Great. Yep. And yeah, as Michelle mentioned, I put the links to both the Women's Caucus page and the LGBTQIA+ page there. So you can not only find out more information about the caucuses, but you can join and figure out what kind of events are coming up associated with those two there. So those are great resources, and anybody can join those. So definitely check those out if you have a chance. And yeah, Misty asked if ACRO is going to share any training or resources or documents in the future as well. And Michelle, I would imagine that's the case.
Yes, absolutely. It may likely be in conjunction with other organizations and things, because, you know, this is sort of a little more nebulous, and while this touches on some of our spaces, it obviously hits a little bit more in depth for student affairs and some of the other campus offices and things like that. So yes, we'll work on creating some resources, some guidance, particularly around the privacy and data issues. So yes.
Yeah, great. And I think those are generally, we would put those in our federal relations area. I can try to dig up that link before we close, but just keep an eye on that for any kind of information. Yeah, and if there are no other questions, I just want to thank once again Melissa and the Women's Caucus, and Tammy and the LGBTQIA+ caucus for organizing and getting this together, and just making sure this is on people's radars, and as well to just celebrate 50 years of Title IX. I don't know if you have any other parting comments, but otherwise I'll try to dig up that link and then we'll wrap up for the day.
Thanks, Mike.
No problem. Thanks, everyone.
Thank you.
Thanks.
All right, I've got it. The Google Foo is working out pretty well. Okay, have a good day, everyone.
Thank you.